Hello, I'm Sean Cullen of Sniper Media Limited. I think it's about time I start actually releasing the proof of my life. I've already been on to a documentary with Tell Me a Secret, and I've also been on a magazine page of The Big Issue talking about my life and my situation. However, this is a request for somebody who's going to be a strong solicitor. My case is a 15-year abuse case. I've got some evidence now, I'll have other evidence to release later. However, I'm going to give you the evidence that I've currently got against Universal Credit alone and my subject access request to start setting the narrative in place. So, we're going to start off with me clearly stating I'm not looking for sympathy here. I'm doing this because I want a solicitor who's going to fight back hard, not a solicitor who's going to sit back and go for the money. I'm not after the money, I'm after the precedent. This is a bit of a heavy topic for me. Like, we're talking about my life, so what I'll do is I'll play the evidence I've gathered. I'll walk you through the timeline of events, the systemic abuse that I went through. This isn't me calling out hatred on the government, it's not me asking to incite violence, this is just me walking through what's happened and asking for a solicitor to step in. I'll also state this now. Do not come after me, my family, or anybody who is associated with me. At the end of the day, what they've done in the past is what they've done. They cannot change it, but it's also not something that needs to be constantly targeted. So we'll look at the first bit of evidence, which is the subject access report. I'm going to scroll slowly through this for you all, so you can get a feel for what's happened. This is 15 years of documented history, starting back in 2011. I'm not going to explain anything. I'm going to scroll through it and let you see everything for yourself. This is 33 pages I'm scrolling through, so I'm not going to scroll quick, but I'm going to keep it semi-constant. If you need to pause this to read anything, be my guest. Since this is my own personal document, I am legally allowed to release this. Everything that I'm releasing currently is all evidence that has been gathered legally. I have asked for this subject access request. I'm releasing this so that whoever wants to fight this can get an understanding of what's happened in the last 15 years. The next videos that I'll be releasing is my personal audits of DWP, which there have been several videos recorded on that one. Those videos have been emailed to Lide, who has refused to get involved with my case. And several other solicitors I have spoken to have also said that they're too full. Again, I am not asking for anybody to go after anybody involved with my case. Frankly, my family did what they did. This is not something that they can fix. It's not something that can be fixed through money, harassment. I'm just simply wanting this to go to court. I want this to be fought. But I'm 22 fighting this. I have further evidence coming from my dad. Once I can pick those documents up, those, like I've said, will be released as well. Just to prove this was 33 pages, that's page 32. Next, we'll go to evidence that's been gathered. We will start with these two, then this one, and this one. I just need to double check which one's the first one so that I can show this video footage.
So for the record, my name is Sean Adam Joseph Cullen. I am joined by
Noah Lloyd, acting as Mackenzie's friend to Sean.
The date today is the 1st of January 2026. The time is 04.54. And this is against Universal Credit. In this recording, we are going to cover the Equality Act 2010, specifically sections 20 and section 149. Then we're going to look at the Universal Credit Regulations 2013 Regulation 35-2-B. And we're also going to look at the UK General Data Protection Regulation Article 5-1-C, also known as data minimization. We'll specifically be looking at Article 9. We're also going to be looking at the Recording Rights Section 36, which falls under the Data Protection Act of 2018, Section 36. And we're also going to be covering Freedom of the Press, Freedom of Information Act. So first of all, I'm going to go through each individual point that's going to be made. Then we're going to compare this to my Universal Credit's work journal and show the statements and harassment that I've been filing against them for the last few months since I've been found to have complex PTSD as found by my GP. We'll also be, for the record, pulling up my subject access request. This information has already been authorized to be put onto this recording for the case of the situation, whether this needs to go to court. So the Equality Act of 2010, Section 20, is the duty to make reasonable adjustments. So for the record, basically because of my CPTSD, Universal...
So what I'll quickly do is just show a little bit of this, because this is pretty long. Just to...
So,
my laptop's almost fully done updating.
So for the statement, as you can see, whilst they've agreed to a Mackenzie friend, they have stated several times stuff like this: please upload information, documents, stuff like this, all into my journal, all onto this information and accounts, threatening financial penalties, prosecution, requirement to repay, and that I may be stopped or reduced. However, in the UK, this law cannot stand because this journal is not somewhere for this information to be passed along. This again falls under, as you can see from our own research with... for the record, we did use Google Gemini to work alongside us to pull all of this up, but we can also put up the exact articles.
I'm also going to be formatting all this in a Word document.
But as we can see here, UK General Data Protection Regulation, personal data shall be adequate, relevant, limited to what is necessary. The information they are requesting is not necessary to prove a PTSD case. Article 9. I've refused unsecured journal submissions to protect my data. So, in terms of questioning the data we are trying to protect, I will go through my phone and pull this data up. I will have to show our WhatsApp messages in order to do this. I will not show too much, just what is necessary. So, media links and docs. We're going to go to Documents, Subject Access Request.
So again, that goes through the subject access request. So I've already done that as we speak.
Our last
That was
incident.
recording, 2 minutes 15 seconds.
Nope, the video recording.
I think we had a video recording.
29th of December 2025.
I'd say less than that.
As you can see, the dates there, time stamped. This is going to be played in its entirety of what happened on this date, of when we went in there. My name's Sean Cullen. I'm here with my legal representative, Noah Lloyd. The date today is the 29th of December 2025. The time is currently around 12 o'clock. The exact time is actually 1:02. This recording is for the purposes of the harassment by...
So I'm going to pause that there. We're going to see that video in its entirety as well, but that just gives an idea of the situation. This is for DWP alone, mind you. I'm going to quickly double check this second recording to see if it's anything of value. I'm pretty sure it is, but I'm pretty sure this goes over my payments that I've had off of DWP.
This is a continuation of the 1st of January 2026 recording. It cut off. But in terms of payments, here's the last payment of December, 129.78, 150, 498, 316.
So yeah, that gives an overall rundown of it, roughly, on payments. I'm not going to sit there and go through all of the payments, because I know a solicitor won't need every single one with the case we're fighting. This next one is a covert recording of Universal Credit, where me and Noah Lloyd had went in and recorded this video with the phone in his pocket. And I'm going to play this in its entirety so you can hear what they state. This is 10 minutes, by the way.
So the date today is the 2nd of January 2026.
3:21 p.m.
12 past 1, 21 past 1 in the afternoon. My name is Sean Cullen. I am here with my Mackenzie friend, Noah Lloyd. We are now going to the Universal Credit Building to hand over
serve a notice of intent
to file. We are not going in to harass them. We are recording this for the safety of ourselves and to capture any evidence we need to capture. Don't hold it down, hold it up. Hold it up. We're auditing them.
This is sufficient.
No, it's not. She needs to capture their body language. As soon as we go by the door, we need to capture their body.
Sorry about the noise here. That's him trying to make this recording covert after we decided it was supposed to be overt, but...
Do you know when he'd be back?
Stand by when. Should be about half an hour. It's not good enough for us.
That's fine.
No. We're here to file a notice.
No, we can wait.
We'll sit down and wait then.
He's not here. He's not here.
Again, they were waiting.
Yeah.
So we'll wait until the person that we're waiting for. We'll cut to
DWP involving my case. DWP we're here to file a notice of intent to litigate. Due to the miscreants of DWP involving my case, we have tried coming in a couple of times to solve this civilly. However, because the harassment has been ongoing now, we will be looking at taking this to court.
That's fine. I'll just go to our legal team, and then obviously DWP Legal will deal with that.
Of course.
No worries. I mean, I'll take this in, and obviously I'll send it off to where it needs to go.
Of course.
No worries.
Obviously, we have offered to provide all the medical documents for the limited work capability assessment. However, I am now officially a disabled person. I have been for the last 15 years.
Okay.
It's just been left misdiagnosed. So when I initially started the claim, that was not you guys' fault. That was on the fault of the NHS.
Okay.
However, since the new evidence has come out, we have tried to request WCA meetings.
Yeah, so I know that you're going down the work capability assessment route because I've seen the claim, so I'm aware of that.
But obviously,
So basically there they've just admitted that they're aware of the claim, they've seen the claim, they're aware that I'm going through the process, however yet they're still choosing to harass me. You're going to later hear off of him about the litigation evidence that I've got against them, but we have a straight admission of guilt.
the harassment, the threat of prosecution that I've received.
Threat of prosecution?
Yes, received.
So what, did we threaten you with prosecution over?
I've had several messages on my journal threatening prosecution.
Saying that he may be prosecuted. If it wasn't for that, I probably wouldn't be here myself.
We wouldn't be here if it wasn't because of the threats that were made in my work journal.
Yeah, no, he doesn't have a clue about that. I can tell he doesn't. No, he's not scared, but he's confused as to why you've been given that. I can tell he doesn't have any clue that's happened. So he's going to look himself now.
This is us two speaking with each other.
That's him again, so good.
The third voice you're hearing is the duty manager.
I've literally got.
The wording is you may be prosecuted. That was the wording.
Oh yeah, I mean that's the standard wording whenever we give out stuff like information. That's standard.
So under the Equality Act of 2010, that kind of wording is actually illegal. So basically they're talking about willful blindness here. Basically we're just getting admission after admission of guilt on DWP side.
DWP wording.
Doesn't matter in the substantial 35.
Section 35, substantial risk.
That is a direct effect on mental health. Because my case is a mental health case.
Oh yes, but that wouldn't change our standardised
Also,
yes, it does. By law, yes, it does. That is legal. Legally, it does change how they treat it.
Because everyone has to be made aware that if they provide us with incorrect information, they may be.
People are already aware of this. However, the way it's worded, you may be prosecuted, which I will show evidence of, potentially. I would have to check the screenshots we have gathered. Doesn't sound like the way he's making it sound worded.
Prosecuted, that's what
also, it's not just that, it's the fact that also inside of this limited work capability assessment, all work commitment files should have been stopped.
Again, under Substantial 35 or Section 35 Substantial Risk to Health, that is also correct information we are providing. Work commitments are stopped. However, also because of my mental health, I struggle with authoritative nature and being in the building. That was also in the subject to access request. So you're going to hear him basically state that, oh, you've still got to come in even though I've had my GP clearly stating that I shouldn't even be there.
However, I've been several times harassed, including financially attacked.
Yes, well, sure, we're pending a work capability assessment. You're not expected to apply for work, that's correct.
It's another admission, but listen to how he's going to try and bypass this, which is not correct.
There will be a certain amount of appointments for us to keep in touch with you as you go along. That's
appointments, no. However, keeping in touch is correct.
We were told it's work readiness, which we've already looked at the law is not correct. That is directly against the limited work capability assessment. We've already looked at this. Hence why we're now filing the litigation.
We filed the litigation, but I'm not sure you're correct on that one, guys, because I've been there for
Now he's going to admit how many times they've been litigated against.
10 years. We've had many court cases going against us.
Maybe
We have had many court cases going against us. They are openly admitting they have been taken to court.
a case of the process is the process you have to go through.
It is just a process. Like, you know, it's all written down in legislation.
Yeah, except when you're going against your own legislation, sadly, bud.
So yes, by all means, do that. But I mean, yeah, we will always.
Also, in the process, it clearly doesn't state to sanction somebody to death, sadly. But that's the two main piece of admission of guilt, well, three piece of admission of guilt that's needed from this. However, what I want to show you, which is the killer in all of this, is how they spoke to me when I went in recording. This is only 3 minutes, so again, I'll let it play through. Well, 2 minutes 50, so I'll sit and let this play through. Now, these videos are all unlisted for my own privacy reasons. However, this video will be matter of public
Today is the
record.
15th of January. The time is 10 minutes past 2. My name is Sean Cullen. This is being recorded for escalation of universal credits against me. I am just around the corner from them. I am not going in there to harass them. I'm going in to collect evidence for the court case that I'm currently in and the litigation process that I'm currently in. I'm not there to annoy, harass, or otherwise scare them, but just to gather last-minute evidence. I'm going to keep my phone up so that we can collect all the data required for this. Like, we're not going to be sitting down taking this. Yep. No, need to speak with the duty manager because this is now a notice of intent to escalate.
Yeah, if you want to take a seat.
Of course.
That's the duty manager there that just walked through. Now, before we continue this, I want you to listen to what they say when they finally realize I'm recording.
Yep. I know my rights. This is a public official building. You are a
He's not allowed to.
Yes, legally I can.
You're not allowed to.
No, it's not.
He's not allowed to.
So this is within 2 feet of me. This is already intimidation. This is already physical intimidation and puts me in a place where I could have legally defended myself.
This is going for court, so if you are saying that it is...
Also, I want to clearly state I am a 55 kilogram, 5'8" male, and it's taking 2 security guards and a third person to surround me and block my exit from the building.
illegal to record, which this is not.
It's just we don't allow it.
It doesn't matter if you don't allow it. Your policy does not require the law.
That is also correct, what I've stated. Their policy does not go above the law.
So are you saying that you're going to be willfully negligent?
Look, I'm telling you that we don't allow video recording in here, and if you wish to continue recording, you're going to be asked to leave. It's simple.
Well, I'll have to section you under 24A of PACE then, potentially.
Okay,
As you heard, Section 24A of PACE, they have put me in a situation where I am threatened, I am surrounded. This constitutes as assault. Assault does not require physical touch. However, they're going to threaten the police, which I've already stated to them afterwards that I've already spoken with the police about their involvement, and I leave.
Good. Sorry, please.
No, you are now committing potentially assault.
Not allowed to record. Central government office, no recording allowed.
It doesn't matter.
Central government office, no recording. That is not correct. Legally, you can record any public official.
You are a public office building.
No,
Can I point out the law to you? Article 8 of the GDPR.
The police will be called.
I've already spoken with the police.
That's fine.
Article 8 of GDPR literally does not actually protect my right to record.
Like, they will also tell you that it's a public building, but thanks for the evidence. This is going to litigating my solicitors. So, as you heard, they became verbally harassive and abrasive. They clearly did not want to answer any line of questioning. You saw them becoming intimidating against me. So, yes.
That's the attitude I had when recording them in public, openly recording them. Now, let's look at a bit of paperwork from my work journal. So here we have them clearly stating, basically they're going to keep me sanctioned. That's what this says. Next, we're going to go to this is just further evidence. I'm not going to talk through this too much, but this is what I've screenshotted from my journal itself. You may be prosecuted, financial penalties. These are just standard threats. You must not ignore this message. If you do, there may be consequences. That is not policy, that is straight up threatening. So next we'll go over this, which is just a quick rundown. I'm not going to talk through this. This was the notice of intent to litigate that I had sent to them. 2-page document, as you just saw. And that was the first page. Like I've said, I'm not going to talk through this. But yes, if you're willing to fight this case on my behalf, please, please, please do get in contact with me on this video. Any help is appreciated against not just DWP, but the whole state. Thank you. As I've stated, another video will be coming out with any other further documentation of my past.